Parties involved in these proceedings include the same lawyers who represented the Attorney General, Speaker Job Pomat, and applicant Peter O'Neill in the substantive matter filed in November. The only new legal representative was Loani Henao, whose application to intervene was granted before court proceeded with the application for leave. In order for a slip rule application to be heard, the lawyers must first seek leave of the courts. This means that the lawyers must convince the courts and prove that they have a strong case of success. Now, in the application that was filed this morning, the three main grounds are that first, there were errors in the dates in the judgment that was handed down last Wednesday. Second, the opposition leader, Belden Nama, was not a minister and therefore was not the right person to move the motion to adjourn Parliament on the 13th of November to the 1st of December. And third, Section 104, subsection 3 of the Constitution that deals with the identification of Parliament sitting and Parliament sessions was not considered in the judgment that was delivered on the 9th of December. The submissions went for at least 2 hours. Objections made by former Prime Minister and Yalibu MP Peter O'Neill through his lawyer Greg Shepherd included arguments that the errors in the dates on the judgment of December 9th were corrected before published on the Pacific Islands Legal Information Institute website. The Attorney General failed to raise arguments on Section 104 during the substantive hearing, and the Attorney General was unable to point to the critical errors in the December 9th judgment. After a 30-minute adjournment, the five-man bench considered submissions from the three parties and found that there was not enough grounds to grant a leave.
Except the court's decision, I got nothing more to say, but only the Attorney General has a duty to bring to the attention of the court, whether this court or any court, if there are errors found in the judgment. So that
outside the courts, the Attorney General announced that he will continue the legal battle by continuing with Section 19 Supreme Court reference.
That's the argument we've raised, and that argument is still strong. And we will take it up in the new Supreme Court reference, and I believe that we will succeed and we will overturn this decision.
Meanwhile, the Supreme Court reference is yet to be listed for hearing by the courts.
the special reference filed by the Attorney General, that arises from the decision of the Supreme Court last week. The Supreme Court, of course, in certain circumstances can direct the Parliament to do certain things. But can it go further?
Thekla Gunga, National EMTV News.